Welcome to K-Talk. I'm Dan O'Gorman, Associate Professor at Barry University School of Law.
I'm Steve Maxwell, Director of Academic Achievement at University of Miami School of Law.
And this is lesson number 3 of our Blackletter series. And in this lecture, we're going to be talking about promises that are legally binding. So in the last session, we talked about what is a promise. And you should know that just because you've got a promise, it doesn't necessarily mean that it's legally binding. You're going to need something extra to make it legally binding. And that is the subject of this lecture. So there it is, Steve. A promise in and of itself might be morally binding, but is not legally binding. Do you think we could have a world in which the legal system enforced all promises?
You know, that would be a very strange and maybe scary world.
People would be very nervous, wouldn't they, about making any sort of promise? They'd be held legally accountable.
Oh my God, and sarcasm. What a nightmare. I use so much sarcasm. I think I would, I don't know, I'd be doing life in prison.
Well, the hope is that under the objective theory, which we talked a little bit about last time, the reasonable person would get your sarcasm, but of course you would run the risk that the jury would conclude that the reasonable person would not have understood it was sarcasm, would have taken it seriously. So yes, that would be very dangerous for someone like you. So fortunately for you, Steve, feel free to be as sarcastic as you, at least from a legal standpoint. I don't know how this affects you in your daily life, but at least from a legal standpoint, feel free to continue with the sarcasm, because the good news is the legal system does not enforce all promises. Merely because you've made a promise doesn't mean it is legally binding. So that means that even if you made it through, let's say you're a communication and you're trying to figure out what you are, and you made it past lesson number 2, you are a promise. That doesn't necessarily mean that you are legally binding. Something extra is going to be needed. And there are 2 principal ways in law that promises become legally binding. They are part of a contract, or they are part of a doctrine called promissory estoppel. And these 2 are going to be related to actual promises. So when we talk about contractual promises and promissory estoppel, we're generally talking about actual promises. We also have some strange being called quasi-contract. Quasi-contract is going to be when the court creates a fictional promise and then enforces it. And we'll talk more about that down the road. Steve, here's a concept that I think students, they don't struggle with too much. This is the idea of formality. So formality describes the form in which a promise is made. And we talk about formality, we talk about things such as it's in writing, it is put under seal, the seal, the old wax seal. Do you have a seal kit? I actually have a seal kit. Do you have a seal kit?
I don't, and I'm not surprised you have a seal kit.
Well, they were gifts. Students, I actually had 2 different students gave me. I have 2 seal kits. And so the seal back in the days of old, and when I mean old, I think I mean like the days of old, like beyond you and me, older than the movie Mr. Mom that we were talking about last time. Beyond, was that 80s?
I think it was 80s.
Yeah, so we're talking like the 1780s maybe.
Oh my God.
Yeah, you'd have a seal. So what would happen is you would have, I guess important people would have a seal, their seal. And you would make a wax imprint. You'd have wax and you would melt it and you'd imprint your seal on a document. And in the days of old, let's face it, if you're willing to go through all of that, you must have known what you were doing. We were going to say, you do all that, that promise is legally binding. The formality alone of the seal would make it legally binding. But you know what happened, Steve?
What's that?
We couldn't let well enough alone. What happened was, does it really have to, the wax is so messy, and who's got where's so you forgot the candles? I thought you were bringing the candles. So what happened was people just they started writing seal under seal. They would write it. Where's
Oh
the
my
seal?
God, that seems too easy, you know? Good grief. I mean, waxing is painful sometimes, isn't it?
I haven't used the kits yet. I've been too scared. There's the point, right? Is that, yes, I mean, it's scary. So you must have known what you were doing. And so people started, Steve, this is the way of the world, isn't it? They started taking shortcuts and they would write under seal. They would also use some Latin phrase, which meant under seal, as if that was like, kind of like, well, shouldn't we at least, if we're not going to use the wax, shouldn't we at least use the Latin phrase? Because that's harder. So,
you know, lawyers are really serious when they break out the Latin.
They are. I remember I was told before I go to law school, somebody told me like, well, you know, you need to know Latin. I'm like, is that true? I don't think that's true anymore. So they would use a Latin phrase, and then it was something like, I don't know, locus sigillia or something like that. I don't know, place of the seal. And then they would even do LS. They would abbreviate the Latin. And then they were putting signed under seal. And my bet you, Steve, you still sign contracts where it says signed under seal. It just types it out, signed under seal. Yeah.
Old school practice, old school practice. Don't do that, guys. If you're listening, don't do that.
Well, you know, what are you doing is the question. Do we even know? We just see it and we sign. So what happened was, if the point of the seal was that if there's enough formality, we should just go ahead and enforce the promise. Because if you're willing to go through all of that stuff, you must have known what you were doing. You must have thought carefully before doing it. And that's good enough to make your promise legally binding. But then people started taking shortcuts. And, you know, that's what ruined it for it. And so what's happened is, because it became so many people, the practice just became to write seal, and the benefits of the wax seal were lost. The idea that a seal makes a promise legally binding is pretty much gone now. There may be a couple of jurisdictions out there, but the general law now is the seal isn't going to make your promise legally binding. And this leads to a broader discussion of formality in general. There's an exception to everything. The formality with which you make a promise, whether it is under seal, in writing and signed, is not going to affect the legal enforceability. It's neither going to typically make it legally binding because it's formality, and in addition, the lack of formality is typically not going to affect its legal enforceability. So the idea of, well, tell me the formality with which this promise was made. Were there candles and in a dark room? None of that generally matter. Other stuff is going to dictate whether or not a promise is legally binding. Steve, I've got the greatest formality case for you. I don't know if this was, I taught it. I don't think I did when you were in class. So this may be new for you. So a man borrowed money. Well, he didn't borrow it. He got the money on behalf of some companies that he owned. He didn't personally guarantee it. Well, the companies defaulted, and he was very embarrassed. He meets the lender in a sushi bar, and he's very embarrassed. He takes out a safety pin. You see where this is going?
I do. I think he's on a roll.
Nice. I got that. See, I'm getting better. Episode 3, I'm getting more into the flow of things. He takes out a safety pin, pricks his finger. It must have been more than just a little prick, let me tell you.
No way. Okay, wow.
You didn't see it coming. So you didn't. And he promises to repay the money in blood, not repay the money in blood. He promised in blood to repay the money.
Right.
And the question was, now, if you think about it, boy, forget about the seal. I mean,
yeah,
you thought
this hardcore. I mean, good grief. That's like it could cost. I mean, you know, we say it'll cost you an arm and a leg, but we're not being literal. Good grief.
Maybe he was just confused. So you thought the seal was painful, and you may be right. I don't know. I haven't used it yet. kids, don't do this. Yeah, he wrote it in blood. And the question was, does the fact that he wrote it in blood make it legally binding? And if you think about it, that's sort of oozing with formality.
Nice.
I knew you'd get that. You're having a bad influence on me. Okay, so it was that's oozing with formality. I mean, the seal's got nothing. I mean, the seal that looks at the seal and is like, really? You think you're formal, but it wasn't enough. So I like to joke with my students. Whenever I talk about formality, I talk about blood, right? Because if that ain't gonna cut it, nothing is. So
wait, are you serious? That wasn't bloody enough?
that was not bloody. So wait.
To make it enforceable, the blood on the case, the sushi?
Oh, I thought you were asking whether or not more blood would have made it binding. Like, did he not use enough?
No.
Is there a level, an amount?
But I can't. Did the court in that case? This is amazing to me.
This is real. Kim versus Sun. And so I think it was, a lot of embarrassment over this and about not being paid back. Kim versus Sun, Kim versus Son, I believe, Kim versus Sun. And it was a very long case, but this was one of the portions that he had apparently done this and written this in blood. And that was not good enough. So yes, so that is it. I don't think, I'm sure it didn't get on the sushi. I'm sure it was all done properly. Maybe it was on a napkin. Ooh, that sounds painful. That sounds painful, doesn't it?
Maybe they just put a pin on it or something.
So it was not binding. Yeah, so that is real. So that is real. So that goes to show you. So students, do not be trapped into thinking that the formality with which a promise is made as a general matter affects its legal enforceability one way or another. It doesn't make it enforceable and it doesn't make it unenforceable. I think a lot of students, because a lot of lay people, because one else, they were just lay people. And I make it sound like this is bad. You're a lay person.
No, but I'm thinking like pinky promise. There's like that thing like blood brothers. There's all kinds of different things that we grow up doing and saying and whatnot. So I don't think you're wrong.
No, this is all very important, but not really probably for contract law. It's not what's going to make it binding. So I think this is more in a moral sense. So I think that the fact that you've written in blood, most promises, I assume, are morally binding. And I think the fact that you've written it in blood is, I don't know, are there degrees of morally binding? Is this really morally binding? I don't know. Or is it binary? But all that kind of stuff, all that ritual that's not going to, in general, not going to make it legally binding. Now, we're going to see down the road, I think you even talked about in one of our first sessions about the statute of frauds, that certain promises that are not in writing are not legally binding. We're going to see so-called firm offers under Article 2, where it's got to be in writing. So we're going to see situations where formality will matter. But as a general rule, the formality with which a promise is made or not made is not a characteristic that affects its legal enforceability. And let's face it, Steve, that's a good thing. Do we really want Kim v. Sun coming out the other way?
Yeah, right. I was just thinking, like, you don't want to go to the sushi restaurant and people are cutting themselves.
This is not a good incentive. Though the sushi place might like it because maybe it's like a whole nother, there's a special room and a whole new area of business,
Right,
make your promises legally binding and then enjoy sushi. Right? But so no, I don't think these are the incentives that we want to create. Let's talk about what incentives we do want to create. We don't want people going to sushi bars and sticking safety pins in their fingers and writing promises in blood. But what we do want to encourage, Steve, and I know you know this because you were an econ.
Yes,
teacher, right?
I was an econ teacher. I was an econ major. I bleed economics.
Indeed. And so you probably agree that we should encourage people to make bargains, to enter into agreements of exchange. Would you agree with that?
Yes, and I'll even just amen it. It's one of the underpinnings of all of contract law. I mean, why would we want to why do we want to bring a court in to enforce something if society as a whole is not getting something out of it? And so I think that's just really like one of the major underpinnings of capitalism, truly.
There is a big debate in contract law, a debate that really should not really bother students or have them devote a lot of time thinking about, in my opinion. It depends on your class and your professor, but it's why do we enforce contracts in general? There are people who believe that the reason we enforce contracts is because there is a moral obligation to keep a promise. So that contract law has moral underpinnings. There's another group, and I don't know that this is necessary either or. There's another group that believes it is really about encouraging people to enter into exchanges to move resources to people who will value them more. And that it is very economic in that place. And so I like to teach that really it's about economics, moving goods to people who value them more, simply because when we enforce a bargain, we're enforcing an exchange. And if we were going to enforce contracts, promises for the moral obligation, well, we would simply enforce maybe all promises, but we're not enforcing all promises. We're not, look, if there's a moral obligation to keep a promise, and that's the reason why we enforce promises in contracts, let's go back to the sushi bar. How do you explain this, the blood case? I mean, that seems to me like a pretty good example of where there would be a moral obligation to keep the guy bled for it. And we don't enforce that. So I tend to emphasize the economic aspect of it. I'm not saying I'm right. Who knows, right? But it seems to jive.
Right. And I think you see the economic rationale more in enforceable contracts. And you see some of the moral obligation reflected in promissory estoppel. At least that's just my perspective. That's how I think of it.
You are welcome. I'm looking forward to that discussion. So you're certainly not wrong. We're certainly moving away from the marketplace, to be sure. So let's stick with the marketplace and contracts. But boy, there's a big caveat here. Is contracts are not, and bargains and enforceable bargains, promises that the law will enforce because they're part of a bargain, are not limited to the marketplace. So many of the cases you'll probably be reading in contract law actually tend to be cases where the contract was not won in the market. I think the reason is cases that go beyond the marketplace sort of test the limits, the boundaries of contract law. Studying the cases at the margins oftentimes helps you understand the concepts better than just a typical boring. I mean, actually, I start with a case that maybe is pretty boring. The very first case I teach, if I recall, is about the sale of cotton. And I think it's a neat case. I mean, there are famous cases. These farmers were growing cotton and they were forward-looking contracts. They were going to sell the cotton when it was harvested, but the contract price was set at the time of contract formation. By the time they're ready to harvest, the price of cotton has skyrocketed. And they're very sad now. They don't want to sell to the original buyers. They want to sell it to the third-party people on the market because the current market price is so high. And so they do sell it to those third parties. Of course, they get sued. They get sued by the original parties to the original buyers of the contract. And the court says, yeah, you've got to sell you were supposed to sell the cotton to the first party. You made a contract. The fact that you're now unhappy, that's not the buyer's problem. You've got to enforce that contract. But many you have to perform that contract. Many of the cases we see in contracts deal with contracts that are outside the marketplace. Oftentimes in the family, you talked about the promise to marry with your girlfriend you're joking about. We see cases where somebody promises their nephew or their niece something and they don't perform. And is that a contract? So yes, although the market is probably moving goods to their more valued users is probably the most important reason why we enforce contracts, be careful. Don't assume as a student that we can't have contracts between family members. This is a complicated issue, but you can. have them. And so be careful. Okay, so contractual promises. So the leading way, boy, like 99.9% of the promises that are legally binding are what we call contractual promises. They are promises that are made as part of a contract, meaning promises that are made part of a bargain. This for that. I promise you X, and in exchange, you promise me Y, a quid pro quo. And there is no need for the parties to manifest an intent to be legally bound. So what that means is, so Steve, let's say, I don't know, give me an example of a very casual contract between two neighbors, one where they don't know a lot about contract law. It's small stakes, nothing big.
If you let me borrow your lawnmower, I'll let you borrow my edger.
Perfect. In that situation, happens all the time, that kind of stuff. And he says, yes, got it. Do you think that those parties, I know I'm asking if you think something about people you just created. Do you think in that kind of situation, they're thinking about contract law, legally binding, going down to the courthouse if there's a dispute?
Absolutely not.
Absolutely not. So the first issue, I don't know, I say it's first issue, an issue that arises, that did arise, is in order to form a contract. Now that's a bargain, right? That's a this for that. I'll let you borrow my lawnmower if you let me borrow your edger. That's a bargain, this for that. Question arose, does that bargain only turn into a contract? And the importance of that is then we've got contractual promises and they're legally binding. If the parties intended there to be a legal obligation, to be legally bound, do we have to believe they had in their minds legal enforceability? Because that's, of course, I haven't even mentioned that, but that's the big shift, right? From morally binding means, okay, people may think you're a jerk for not performing. You might have social ramifications, but you can't be, we could be sued, but you're not going to be held legally responsible by the government and be ordered to pay compensation as a result. So that's a big move from moral obligation to legal obligation. The general rule is that if it is a bargain, it is a contract, and therefore it is legally enforceable, even if we don't believe that the parties at the time they made that bargain were intending to be legally bound. They were, even if they weren't thinking about legal enforceability. Because if you think about it, that would sort of, I don't know, wouldn't that, I think that would cause a lot of havoc. Wouldn't that wreak havoc on, as a contract? I don't know, maybe some people would like it because it would get rid of like these casual deals and people aren't suing over casual deals. So maybe some people like this idea that you should have to intend it. But could you imagine if we impose this requirement, could this potentially create some havoc on things?
Absolutely. I like it. And just the lying and the, you know, all this other, you know, I think it would escalate conflict actually.
Could you imagine the deposition? If you're asking me, like you're trying to get me to admit that I was intending this to be legally binding. And I'm like, let's say I'm like, you know, I don't know. I'm unsophisticated with respect to the law. I don't know a lot about the law. And you're asking me these questions like, do you intend to be legally binding? And I'd be like, what do you mean? Right. What do you mean legally binding?
Yeah. Yeah. Like, what are you talking about? But it you know, it takes us out of the realm of the internal, which I think is one of the, it's one of the more befuddling parts of proof, you know, like just coming up with proof and evidence of what was in somebody's head. I know we have to do that in criminal law to a great degree, but there we're dealing with, you know, more serious events, I would think. The
remedies are more serious. I mean, you can go to prison, jail, right? So in other words, with contract law, it's like, hey, I didn't intend that. Yeah, well, it's not that big of a deal. We're not throwing you in jail. Not that remedies can't be quite significant. You can have large amounts, but we're not throwing you in jail. So maybe we don't feel that bad about the external.
Right. what was your intent when you handed over the edger? Like, what do you mean?
Right. Didn't you intend this to be legally binding? Huh? What does that mean, legally binding? Okay, we're going to make things a little complicated. Are you ready?
Ready.
Okay. Although the parties need not manifest, and look, objective, need not manifest an intent to be legally bound, no contract arises if the parties manifest an intent not to be legally bound. What do you like that? Like that?
So you like walk around with a disclaimer?
Yeah. Okay, and this actually happens. I got an example for you. That not exactly.
I bet I knew you had an example.
Well, it's not. If you're expecting a great hypothetical with a person walking around with, a whiteboard around their neck saying, "I don't intend to be legally bound." Maybe that could be a T-shirt. I don't intend to be.
Yes. Bound. Oh my gosh. K-Talk. I don't intend to be legally bound.
Oh, we have to have a whole line of merch. I think that's what they call it, right?
Oh merch. My God.
Yeah, yes. Steve, I think we're getting about 150 views. I think we're a little ahead of ourselves. Okay. But so here's an example, not as interesting as you might expect. Employee handbooks. So, you start work. Look, you've just started work. There's probably an employee handbook floating around. I think I cleaned out my office. I found an employee handbook. I went to a treat. You get employee handbooks as an employee. Very common. Many of those employee handbooks include a provision within them that say nothing in this contract, nothing in this manual is a contract. So you actually do have people who are sophisticated enough to remember we talked about the accidental promisor. So you can have an accidental contract. And the way to avoid accidentally entering into a contract is to manifest expressly that you are not intending to promise or enter into a contract. So what we have here is, although in your hypothetical with the edger and the lawnmower, a reasonable person would presume, right, we don't care that even if a reasonable person think they're not thinking about being legally binding, that doesn't matter. The presumption is it's a bargain, it's legally binding. But if a reasonable person would believe that the parties had manifested an intent that their that their bargain not be legally binding, it isn't legally binding. It doesn't become a contract. Now, I gave an example of a way to do that expressly. You put it in a handbook. This is not legally binding. Great. Done. Here's where things get a little complicated. And I should note that with the express, the idea is that, yes, Steve, as you mentioned, we don't want to be spending a lot of time thinking about the subjective, getting into that. But we're not going to force you to enter into a contract and make it legally binding if you don't want it. And if we're concerned about people relying upon what other people say, if they tell you it's not legally binding, we're not going to make it legally binding. They told you it wasn't legally binding. What's your problem? Why did you take them serious? You weren't justified in believing this was a contract.
It's kind of like, if you go back to that definition of a promise, this is like sort of negating the commitment of a promise. If someone manifests some contrary intent,
it's very similar. So what it is, I think it's one step difference perhaps in that the promise, I would still think you've got a promise. You're absolutely right. So let's take promise. We know that a promise is a manifestation to act or refrain from acting in a specified way. Fine. And then the promisee has to be justified in understanding a commitment's been made. So if you want to stop short of promise, this is all about stopping short, isn't it? If you want to stop short of promise and just stay in statement of intent, then what you do is you make it quite clear. That's easy. It's like the illusion. I intend to do this, but let's be clear. I am not promising. So Steve, you say to your girlfriend, I intend to marry you, but let's be quite clear. Say it quickly. When she says, I accept. Let's be quite clear. Always the romantic. I am not promising to marry you. You pretty much you need to have a law student or lawyer girlfriend at that point, or it's over. But the lawyer girlfriend appreciates it. She's like, Yes, you're perfect for me. I married a lawyer, right? So it says a lot about how romantic I am. So you could stop short. Same with, you can have a promise. Steve, I have a bargain for you. I promise to loan you my lawnmower if in exchange you promise to loan me your edger. But so we've got promises. I didn't stop short at statement of intent. I went to promise. I'm promising, I'm making a commitment, but I want to be clear. We are not assuming any legal relations here. So what's interesting is what you end up with is you would end up with an exchange of promises. They're not statements of intent, they're promises, but all you're left with is a moral obligation to perform. And the reality is a promise that is not legally binding in a legal sense is no different from a statement of intent that never became a promise. If you're not legally binding, I don't think do we care about you? I mean, so at that point in time, you're basically pinky swearing, writing in blood business. So when we make this exchange of promises, what I'm telling you is you can count on me. I'm asking you to trust me. But if I don't perform, I want to limit the consequences of my failure to perform to you thinking I'm untrustworthy and a jerk and telling all the neighbors, don't trust that guy. I don't want one of those to also be consequences, to also be, I can be hailed into court. So that is, so that's sort of the, and you may be sort of wondering like, well, wait a second, can I trust this guy at all who makes the promise but doesn't want it to be legally binding?
Right. And the way I'm thinking about this at this point is that promises with a bargain are enforceable, but the parties can opt out of that default position. Is that right thinking?
Perfect thinking. So this idea of what we call default rules or presumptions are very important in law. It's this idea that we are in opting out, as you said. It's this idea that we're going to have a lot of situations. We are going to assume X and we're going to go with X. We call that the default rule. You could also phrase it, say it's a presumption. But if the parties want out, they need to opt out. They need to make it clear. So perfect. I would definitely say it that way. You can say that either our default rule is that it is legally binding unless you opt out, or we're going to have a presumption that is legally binding unless the parties opt out. Here's where things get complicated. You can impliedly manifest an intention that it not be legally binding. Oy, wow, this is problematic now, right? Because as we talked about last time, I'm talking about implied in fact here. When you talk about promises, implied in fact versus implied in law, if a reasonable person would believe that the parties are manifesting an intent not to be legally bound, they're not saying it expressly, but a reasonable person would believe that by the mere nature of the type of bargain or the context and the circumstances, they're indicating impliedly that they're not to be legally bound, then they are not. They've opted out. So you can, Steve, you can impliedly opt out. And this is where things get tricky. Now, students need to not overuse this, in my opinion. This is going to be very unusual. Typical examples, there's two typical examples. One is domestic. I need to get adjectives in here. I need to be very careful. Typical domestic arrangements. Please don't ask me for a definition of typical domestic arrangements. I don't have the slightest idea what what typical means in that context. But I can give an example which we know would fall in the line of, would definitely be within typical domestic arrangement. I say to my wife, I have a deal for you. I will take out the trash if you clean out the cat boxes. And she looks and she says, deal. That's a bargain. Students will think this is not a bargain. That's a bargain. But a reasonable person would not believe that we were intending it to be legally binding. And the manifestation part really is just from the mere fact that it's the context, it's the nature of this deal. It's just your typical domestic arrangement. And it would be ridiculous to think that we were indicating that I don't think we're not just sort of neutral on it or not thinking about it. We almost think that we are sort of indicating that this wouldn't be legally binding because it's so absurd to think that it would be. So your typical domestic arrangement is an example of a bargain that is not legally binding, and typical social engagement. So, for example, Steve, we were supposed to start today at 2 o'clock, were we not?
Yep.
It's very possible that one might have construed me as having promised that we would start at 2 o'clock. Is that right?
I'm with you. Yes.
Now, I don't know if this is a social engagement or not. I tend to think of it like, who knows? This is the problem with labels like this. What's a social engagement? I don't know what a social engagement is. Is this a social engagement? I like talking to you. I mean,
yeah, it's arguable here because this is fun on the one hand, but on the other hand, it has a lot to do with our profession.
We're wearing jackets.
Right. And I never wear a jacket outside of the work context.
Not in a social, right? Not so right. Why would you do that? So it's watch out for labels, but typical social engagements. The classic example is a lunch date. I will meet you for lunch. I was late for lunch today. As you know, I told you the events that transpired with me this morning, and everything got kind of pushed back. So I was also late for lunch. And the question is, would a reasonable person believe that when I scheduled that lunch for 11:30 a.m., that's when people my age eat lunch? Because, you know, that's only, if you're going to eat dinner at 5, you need to have lunch at 11:30. So would a reasonable person believe that I had manifested an intent to, manifest intent to not be legally bound? I always said to be legally bound. That's the wrong way. Have I manifested to opt out? That's a classic example of where you would have opted, a real person believe you opted out, typical social engagements. But please, students, we probably spent way more time on this than we need to. These are very unusual. It's really, if it's just something very kind of trite, I would not overuse this. And if you see like a significant, you know, if people don't really know each other that well, or it's even between family, but it's something significant, probably we wouldn't construe them as having opted out. All right, Steve, anything on that before we shift into the elements of a claim for breach of contract?
No, this is the meat and potatoes right here. Let's
this is it. So I like to think in terms of litigation. I was a litigator, and the way I like to think of it, all rights and duties, this is probably wrong, but all rights and duties kind of, the point is you could end up getting sued, right? If you don't perform and discharge your duty. So the elements of a claim for breach of contract are, not surprisingly, that you form a contract and then that there was a breach of the contract. I remember I used to ask in open house and things like that, and say, okay, what do you think the elements are of a claim for breach of contract? And students would struggle. I'm like, okay, think about it. It's a claim for breach of contract. And let's assume there's 2 elements. What would you think those 2 elements would be for a claim for breach of contract? And not,
but there's the trick. See, breach of contract starts with contract. That's the trick. Contract, then breach.
It's breach of contract. So yes, you have the contract first, and then you breach. And maybe that's what was causing them confusion. But so those are your elements. And it's pretty basic now. We'll have more discussion down the road on other lessons about, a lot of discussion about how do you form a contract and what does it mean to breach it. I think the most important thing for this lesson is to recognize that one way, the most important way in which a promise becomes legally binding is that it is made as part of a bargain, a quid pro quo, a this for that. And we call those contractual promises. They are legally enforceable because they are part of a contract. All right, are we ready for promissory estoppel?
Oh, it's one of my faves.
Okay, here we go. Promissory estoppel. So the most important feature, I guess, the distinguishing feature for promissory estoppel is not bargain. You don't need a bargain. You don't need an exchange. You don't need a quid pro quo. But somebody made a promise, and even if they were not receiving something in exchange for that promise induced the promisee to detrimentally rely on the promise. And then the promisor, of course, doesn't perform, they breach, and the promisee is very unhappy because the promisee has been left in a worse position than they were had the promise never been made. And we've got a lot of elements here. The elements of a claim for promissory estoppel are a promise, number one, of course. Number two, the promisor should reasonably have expected the promisee to detrimentally rely on the promise. Three, the promisee in fact detrimentally relied on the promise in the manner that should have been expected. Four, a breach of the promise. And five, injustice can be avoided only by enforcing the promise. I like to say promissory estoppel is, I don't know if it's the claim for losers, but it's, if you don't have a contract and you're suing for breach of a promise, you're not in a great position, in my opinion, because you are sort of going out of the realm of the typical way promises become legally binding. And it's not necessarily a great place to be. But if it has induced detrimental reliance and you can satisfy these elements, detrimental reliance being one of them, you can establish a claim for promissory estoppel. Steve, is this a concept that is confusing for students?
I'll tell you, it's funny you asked me that. The funniest part of promissory estoppel, in my experience, is the element that students forget or they leave out, and that's a promise. They remember everything else and they leave out the promise, and they can't, like, you're out the door. You can't, unless there's been a promise, you can't be in promissory estoppel land. And then the other thing that they confuse is they blend contract with promissory estoppel, and they don't see that those are completely separate decision trees. It's either a contract or it's promissory estoppel, and they can't bleed one into the other. And so this is the first point of, I think, real blending. And then they don't identify the promise or analyze the promise element. Everything else they seem really good with. I know that's strange, but I'm on the bar prep side of it.
And I agree completely with you. And I see that with the students when I teach them as 1Ls, and you're seeing it 2 years later. And I think that we see this for a couple reasons. So let's talk about forgetting the promise part of it, which in some respects is sort of surprising. It's called promissory estoppel. And right off the bat, let's just be clear, the name's terrible. The name's horrible. I don't mean like, hey, you could have like had a cooler name. It's not, it does a bad job because estoppel is not really what's going on. Estoppel, a lot of the students are probably watching, it's like, what's an estoppel? Estoppel means basically it means to be estopped. I think it comes from the French, to estop, to be stopped, to be barred. Estoppel was typically and traditionally something defensive. Somebody would get up and make an argument, and the other side would say, he can't make that argument. He's estopped for some reason. There's some reason why the other side, or she is precluded from making this argument. And we had classically, say, equitable estoppel, which was the guy on the other side would get up and make an argument that, of X. And the other guy would jump up and say, he can't say that it's X because he told my client before this litigation that it was Y. And my client relied upon the fact that it was Y. And now he's saying it's X. And we call that equitable estoppel. There had been a misrepresentation of a fact, remember, not a promise, but a misrepresentation of a fact that had caused detrimental reliance. And we call that equitable estoppel. And it was defensive. He can't make that argument, Your Honor. There was also something, and still is, called judicial estoppel, where a party would make an argument in litigation and win on that issue. And then later down the road, they would want to take an opposite position. And the other side would get up and say, he or she can't make that argument. They argued X and won on it, which is sort of like the reliance, almost like the court had relied on it. and now is trying to like have it both ways. And we call that judicial estoppel. So estoppel was it was defensive. It wasn't offensive, Steve, right? It was, it's going to get offensive. I don't know, see how much.
Right. And this is offensive right here. Promissory estoppel is offensive.
Promissory estoppel is offensive. So what promissory estoppel does, promissory estoppel actually gives you a cause of action. You don't just stand up there and go as defensively, hey, promissory estoppel, he can't do that, promissory estoppel. You actually can sue in your clause of action instead of say, but like, where you sue for breach of contract, here you're using promissory estoppel just like you would with contract as a cause of action. And it's offensive. Truly, it is offensive. And so the word estoppel is not a great word, but this is what happened, is that we didn't know what to call this thing. Well, yeah, we know what to call this thing. Courts were enforcing promises when there was detrimental reliance, but it was starting to happen and there wasn't a name for it. And the name promissory estoppel was picked. Promissory, great, no worries, there's a promise. Estoppel was a weird one. This is the way, it probably was because there just wasn't a better name for it. Estoppel most likely came about in this phrase because what was happening is people would sue on a breach of a promise and the defendant would get up and be like, yeah, well, there was no exchange here. There was no contract. It's something called consideration, which we'll talk about down the road. There was no bargain, no consideration. And the other guy would get back and say, oh, no. Yes, but my client detrimentally relied on that promise. So that guy, the defendant, shouldn't be able to argue that there's no consideration, there's no bargain, because my client detrimentally relied. And when the idea was that courts were buying this argument that a party who had made a promise that induced detrimental reliance would be precluded, would be stopped from arguing that there was a lack of consideration, lack of a bargain. And the problem with this is promissory estoppel started being called a, quote, consideration substitute. Instead of consideration and a bargain, you have detrimental reliance. But here's the problem for students, and it's one that you've talked about, is when we talk about the elements of contract formation, every law student is going to know and learn that the elements of contract formation are offer, acceptance, and consideration. When you call promissory estoppel a consideration substitute, many students think that simply means that promissory estoppel, detrimental reliance, takes the place of the consideration requirement in contract formation, but you still need an offer and an acceptance. And so, yes, they're going down the contract road and just stepping aside briefly for promissory estoppel and detrimental reliance as a consideration substitute. And then they get back in and they continue down the contract road. And you know how I know students do this, Steve?
No, how do you know this?
I've seen it.
I've
feigned shock. I've gambling in Casablanca. I have seen this. So I think so the name is terrible. I think the name is terrible, both in respect that the name's terrible in that it's used offensively. You sue for it. And it's also, I think the problem arises that students are taught this is a consideration substitute. It's probably better to call it just a contract substitute, maybe, or a bargain substitute. It's totally separate, totally distinct. These elements that you see, these five, these are it. You nail these five elements, you succeed on your claim for promissory estoppel. This is a totally separate slide. You're never looking at offer, acceptance, consideration. Those are absolutely irrelevant when you're trying to establish the elements of promissory estoppel. It is just these five.
Right. And this does, if these five elements are met, there's no contract, right? It just makes the promise binding.
So what there need not be. So what many courts say, and this is what I teach, is that if you do have a contract, and the contract was breached, you have to sue on the contract. And there's a lot of reasons, I mean, not a lot. There's reasons why you would want to do that as a plaintiff anyway. But the idea is that these are alternatives, that if you have a contract and it was breached, contract is formed and it's breached, that's your go-to law. And that's your traditional way to analyze the problem. Promissory estoppel is relegated for those situations when, for whatever reason, a contract there was a promise, but a contract didn't form. Maybe there wasn't a bargain for exchange. There wasn't any consideration, or maybe there wasn't an offer because it wasn't definite enough. We'll talk about that down the road. But yes, promissory estoppel is for those situations when, for whatever reason, either there was never an attempt at a contract, just a straight up promise that induces reliance, or maybe there was an attempted contract, but it failed to become a contract because it didn't satisfy the requirements for a contract, which of course we'll talk about down the road. Now, a little wrinkle here, and I know this is sometimes hard for students because they haven't practiced yet, and you may not appreciate this until you practice. You can plead when you file a lawsuit, you file a complaint, you can include causes of action that are inconsistent with one another, just pleading in the alternative. I mean, you're not supposed to say X happened, if you know, and then you say, well, Y happened. I mean, if you're not sure, you can do that. But you can always plead alternative legal theories. So you can plead, say, in count 1, breach of contract, because you feel that you got an argument that this promise was part of a contract, but you don't know how this is going to go down. You may lose on that. And so as a plan B, you can have count 2 as a claim for promissory estoppel. You can't win on both contract and promissory estoppel. It's either one or the other, but you can't assert both in the same claim. And so maybe now, Steve, you want to talk about how students should approach that, say, on an essay, whether it's law school or the bar exam. I'm sure on the bar exam,
absolutely.
They would be expected to talk about both of them if they're both potentially possible. Is that right?
Yeah, absolutely. And students always want to know, how do I do that? How do I argue two different things that are not connected? And I think, I would, if it's clearly promissory estoppel, I think I get in and out of the contract and go to promissory estoppel. If it's arguable both ways, I think you argue one of them completely and thoroughly, and then say, but if a contract, if a court finds a contract is not formed, then the next issue is whether the plaintiff has a cause of action in promissory estoppel, and then go through and outline those elements and then argue those facts. And so you don't have to be inconsistent in your writing. You just say, if a court finds this isn't the case, then we go here, and then you begin to outline that one. It's very, very quick transition. Don't waste a lot of time on it, but I think it helps demonstrate to your prof that you can think like a lawyer who's drafting that complaint with 2 counts, and you are essentially doing that on the final exam.
Yeah, exactly. And there may be some situations where it's 100% clear, and I'll just talk about my exams. I'm not a bar prep expert. If it's absolutely clear that a contract is formed, and that could happen if it's the final exam, it's possible that I say X and Y enter into a contract. And so the question is more about, say, defenses or excuses or the remedies. I personally wouldn't expect you or want you to talk about promissory estoppel because clear contract is informed. But in any situation where it's debatable and it's not certain that a contract had formed, I would expect you, if it is consistent with the call of the question, to talk about this alternative way, promissory estoppel. I think that students are, my experience has been that students are often too quick to go to promissory estoppel. If it is, they see detrimental reliance, they want to go right to promissory estoppel. Students should remember, again, 99.9% of the time, if a promise is legally binding, it's because it's part of a contract. And even if it is debatable if a contract is formed and you're seeing tons of detrimental reliance, you still want to make sure to first analyze whether a contract has formed, because that's when the courts are probably going to be more receptive to. Some courts can be fairly hostile to promissory estoppel claims. They view you as sort of getting something for free. Contract is, hey, this for that. Yeah, you get a promise that's legally binding because you gave a promise that was legally binding. But with promissory estoppel, you didn't give anything up, and you're perhaps asking for something without having given anything. So you don't want to be too quick to pass over contract formation. The elements. Okay, the first one is a promise. Steve, I'm a mean man. So you said that students often forget there's a promise. So I am very aware of this, that you need a promise and promissory estoppel. But they're just thinking detrimental reliance. So I had a question on the exam, which is it mean? I don't know. I just write, you tell me, I just write the questions. So, and I remember one time, didn't you say one time, you said that if there is a really, really sympathetic party on my exam on the multiple choice, the right answer is they lose?
Yes, absolutely. And I would do that with any prof. If they ham up a sympathetic character and a fact pattern, they're setting you up to take the bait.
And the bait here, of course, well, in this debate in all those classes, you're right, which is that the reality is there is a distinction between a moral obligation and a legal obligation. Now, many legal obligations are premised on moral obligations, but technically there is a distinction. And so just because something is morally binding doesn't make it legally binding. And when we do that, we're trying to make sure you remember that, not because we want to suck the humanity out of you, but just because we're training you to be lawyers and that's the way the law works. Walking into court, it probably works better with juries, I'm sure, right? But walking or making an argument to a judge that your client should win because your client's sympathetic, that's not going to work. I mean, the judge wants to hear law. And so it's easy to write a question where it seems like somebody's being a total jerk. And really in the realm of moral obligations should lose, but it doesn't mean that they would lose in a court of law. And so what I did one time is I had a question where, so a woman saves a guy's life. She takes him to the hospital, says, I don't know, why am I smiling this one? I'm smiling when I say this mean question. He's in the hospital and she saves his life. She like waits for him to come to and all this. And he doesn't promise. He says to her, oh, thank you so much for saving my life. I intend to pay you $10,000. And she's like, oh, thank you. And she goes off and I don't know, bought something for her kids or something. Oozing detrimental reliance, right? And it was foreseeable. I think she even said like, oh, that's awesome. This money will really help me and all this stuff. And then, she spends this money that she can't afford, of course. And he never pays it. He's just a total jerk. And of course, he has like tons of money and he just doesn't pay.
Of course. And she's really needy.
Of course. And she sues him. And they say like who will win? And, the first one's contract. The second one's, is promissory estoppel, and I don't know what C and D were. And of course, you can see where this is going, is that it was, if you hit the rewind button back to the hospital bed, and you hit the rewind button on our podcast, and you go to episode 2, what is a promise? You'll notice that he stopped short of making a promise. He left it, he just a statement of intent, no language of commitment. And so she was relying at her own risk. She was relying on him carrying through with his intention, but it wasn't a promise. And if it's not a promise, you can't satisfy element number 1 on a promissory estoppel. It doesn't matter how much detrimental reliance you have. So yeah, when you said that, I thought of that question. So please, students, please be careful to remember that you do need a promise. Now, something I see that often happens with students is they mix up elements 2 and 3. Element 2 is that the promisor should reasonably have expected the promisee to detrimentally rely on the promise. We are focusing on what the promisor should have expected. Should the promisor have expected the promisee to rely on their promise? And number 3, did the promisee in fact detrimentally rely on the promise in the manner that should have been expected? So question number 3, element number 3, is about whether there was in fact detrimental reliance. So they're different. They're focusing on different parties. And to give you examples of how they differ, element number 2, I might make a promise. Typically, I think it would happen where maybe more element number 2 is satisfied and 3 isn't. Element number 2 would be where I make a promise to you and it's totally foreseeable that you will detrimentally rely. You tell me, oh, I can't wait to get the money. I'm going to go, I'm sorry, I don't say that. I'm so excited that you promised to give me the money. I'm going to go out today and spend the money on this. I look forward to then getting the money. So it's foreseeable that you're going to detrimentally rely on my promise. But you leave and you're like, is this really a good idea for me to detrimentally rely on this promise before I've got the cash in hand? No, it isn't. And you don't detrimentally rely. So that's the difference between 2 and 3. It's focusing on first, number 2, what the promisor should foresee, detrimental reliance, and number 3, then did it in fact end up that there was detrimental reliance?
And, and I know we're not to the 5th element yet, but back to the first episode of K-Talk, when you mentioned Professor Rook's chain link. These are elements. If one of them's missing, the whole claim fails, which is why it's so important to get each and every one of these correct.
Exactly right. Thanks for mentioning that, because that's absolutely right. These are elements. You'll see an and there at the end of 4 and the beginning of 5. So you got to have them all. So number 4 is a breach of the promise. I add this. A lot of professors won't. If you look at, say, the restatement of contracts, it just says when is a promise legally binding under detrimental reliance, and it doesn't talk about breach because it's just asking if it's legally enforceable. It's before breach. But I like to think of the elements of a claim for promissory estoppel, not just when does promissory estoppel make it legally binding, but when you're going into court and you're asserting a claim for promissory estoppel, what do you have to prove? And of course, you'd have to prove that the promise was breached. If the promise wasn't breached, obviously you don't have a claim. Okay, you had mentioned the 5th one. Oh boy. Wow, anytime you see the word injustice or what is just, you're entering the realm of what we'd call a standard, not a rule. Standards, and I can't remember if we talked about rules versus standards yet. We may not have. It's a pretty important concept. Rules are things that are clear. We may have, right? You have to have 18 to have full capacity to contract. All I need to know is, are you 18? It's not fuzzy. Standards are things that are fuzzy. And I think we did talk about this because we talked about factors versus elements.
Yes. And where there's fuzzy, that's where your prof puts a lot of facts. And that's where you need to really focus and be prepared to argue on an exam.
Exactly. Because think about it. Injustice can only be avoided by enforcing the promise. That is not clear. That is not black and white. Like, say, are you 18 and thus have full capacity to contract? What does injustice mean? What injustice means to you may not be injustice to me. It's fuzzy. It's what we call a standard. So facts are going to matter. Now, we talked about this idea not only of facts, but of factors, right? So factors actually point a spotlight at certain facts that are going to be considered important to courts in deciding whether injustice can be avoided only by enforcing the promise. Because if you think about it, and just to say, well, talk about injustice, okay, and you're off talking here and there, and this is just, and I don't know, I hear a reference to, I don't know, Nietzsche or something, and moral philosophy, okay. But courts oftentimes like to sort of rein in these standards that are vague and identify in advance the kind of things that they are going to consider important. And these tend to be the things at a minimum you should look for. Yes, you can go beyond. You talked about that, right? I think you talked about one of the prior episodes about scanning for all the facts that you can grab. And that's absolutely true. But at a minimum, if you know there are factors that are identifying particular types of facts that we know for sure will resonate with the court, you definitely want to look for those at a minimum. And the good news, it is good news. I know students don't think it's good news. They think it's just more, and more is bad. The good news is that we actually have, I don't know why I say actually. I excise actually from your vocabulary pretty much. It almost never adds anything. We have 3 factors that have been identified that courts will consider particularly important in deciding whether injustice can be avoided only by enforcing the promise. And before I get to those three, I want to back up for a second and talk about what element 5 is doing. Why is it there? I have a theory. My theory is if you didn't pay for your promise that you received, it's not part of a bargain. I'm very suspicious about this. You want a free lunch. Why? You want to enforce this promise? You want that guy's promise to be legally, you want to hold him legally accountable for not performing? Well, did you pay for that promise? No. Oh, so you're here for a freebie. Yeah. But I detrimentally relied. Okay. I'm still not loving it yet. To me, what element number 5 is like this big gatekeeper. Most of your cases, I think, say on essays where you're debating it, don't go straight to element 5. But element 5 is where the fight's going to be, where the blood, so to speak, is going. A lot of blood in these episodes. The blood is going to be, because usually a promise has been made. Usually, it's usually foreseeable that a person will rely on your promise. They either detrimentally lied or they didn't. It's not hard to figure out. And now at number 3, at least under the second restatement test, which I've given you here, is not about whether you have a lot of reliance. It's just, was there detrimental reliance? Yes or no? Don't talk to me about how much yet. Yes or no? Usually the answer is yes. 4, was there a breach? Usually the answer is yes. I think where really the fight is on this last one. And what I think this is this is sort of the big gatekeeper one, which is, okay, you want something for free. I'm only going to allow you to make this promise legally binding if I think there's a really good reason for it. Typical promise not kept, you detrimentally lied, go away. You're wasting my time. This is where I'm going to sort of, this is going to be the litmus test, kind of an acid test. And so the kind of things that the courts are going to look at are, number 1, the reasonableness of the promisee's reliance. I'm not exactly sure what that means. I mean, I guess we have a spectrum of reasonableness. So it was really reasonable, or like, yeah, it's a close call. I mean, it was foreseeable that there would be reliance, and you did rely, but even though it was foreseeable, maybe we think it was still unreasonable for you to rely, or maybe we think it was reasonable, but not very reasonable. So the whole sort of question of like, okay, it was foreseeable you'd rely, you did rely, but now let's talk about whether it was reasonable. And number 2, if it was reasonable, how reasonable? I don't know. What do you think?
Yeah, no, I think that's the only one with teeth. I think it gives the court the role of figuring out whether this situation merits compensation. I think it just gives the court all the discretion in the world. It seems like this is such a fuzzy standard. And I remember feeling this way as a 1L, wondering, I thought the law was clear. I thought the law, sort of sorted these things out in a more mechanical way. And this elements of standards like this just really kind of threw me for a loop. I was appalled at how much discretion a court had.
So that's what it was when you ran out of class that one day screaming.
Oh, that could have been anything.
Well, it happened numerous times. No, I'm kidding.
Yeah. Well, I had that pin. I was signing a contract in blood.
Yes, the blood trailing. So that the blood stain is still there to this. We never get it out, and we've never changed the carpeting. So it's true. So students need to get comfortable with this grayness, that you are going to see some situations where the rule of law is vague, and who cares if that's good or bad? It could be good, it could be bad. It could be bad in the respect that you think it's now arbitrary, it's hard to predict. It could be good in that it actually does a better job of getting a correct result because the court has the flexibility. What it means for you as a law student, it seems to me, is recognizing that when there are standards like this is probably the kind of area where you are going to dive in on an essay and be able to make competing arguments element 5 is good for an essay. Element 5 is not very good for a multiple choice. So for a multiple choice, to make a promissory estoppel question like this, multiple choice, you've got to really load it on one side. Like all the factors, they all fail. There's, it's, what were you thinking when you relied? I mean, were you crazy? And your alliance was very small, perhaps. But if it's debatable, that's when it is essay time. And I like to joke about how the law does not care. We're just about the law. It doesn't care about what is just. It's what is the law, except when the law asks what is just, right?
Yeah, absolutely. I'm going to piggyback on that and say things like this, arguing the reasonableness of the reliance. I think that's one of the few areas where you can really get creative with your arguments and your facts. And you're stuck with the law. You're stuck with the elements. The elements are not changing. That's what you have to deal with. But something like this, you can really get creative. And so if you're finding it too mechanical, I think this is really kind of going to ratchet up your fun factor. I know I had a blast when I could think of ways to argue these fuzzy standards. That was fun for me. And that was a little bit of a creative outlet. There's not a lot of creativity in whether the promise was breached, but this is a little outlet for creativity. At least it was for me on an essay.
And let me let you know about a little secret. I'll let you in on a little secret with professors grading exams. I say we, I can't speak for other professors. I like seeing that creativity. Because if I've got a stack of exams and it's all just this mechanical essay and just, applying the rules and I'm not seeing any creativity, I'm not enjoying this very much. I mean, it affects your grade. It doesn't affect your grade because I'm not enjoying it. I'm like, oh, I'm not enjoying this, bad grade. Now, I would never do that. But a good essay exam is seeing these standards and making competing arguments. So odds are, if you are making interesting competing arguments, you're entertaining me. And so the exams that entertain me, not like you make a good joke, but entertain me like, wow, that's an interesting use of the facts. And, you kind of like that as a professor. You may include facts in there and you didn't even realize they could be used in that particular way. And I really like when I see somebody using facts. I'm like, wow, yes, that was not my intent, but that's a good argument. And that tends to generate good scores because what that's doing, you're not getting a good score because I'm entertained. You're getting a good score because you are demonstrating a real ability to marshal facts. That's what good lawyers do. Good lawyers marshal favorable facts to their side, and they do damage control on bad facts. So that's another thing that's really great. When you read an exam and you see a student acting on behalf of one side and I shouldn't say don't ever, I can't speak for all professors. Always follow what your professor tells you and get guidance from him or her. But a lot of professors on essays will like to see competing arguments. And what I love to see is when a student is actually doing damage control on a fact that they just argued on behalf of the other side. So they're like, plaintiff's going to argue this. And I'm like, wow, that's really good. And they're using this fact. And then they turn on a dime and they then explain to me how the argument they just made is not a very good argument. And those students, I think, just sort of get it. They understand what you're supposed to do with these standards. And you're supposed to try to make those competing arguments. So yes, this element number 5, if you're writing an exam and you're doing a promissory estoppel analysis, odds are you're not doing a great job. If you're treating elements 1 through 5, you're doing like a quota of 2 sentences per element, because element number 5 is screaming for more attention. It is it's a quintessential standard, and it's screaming for the use of facts and grabbing them. With the other ones, not so much. They could be, but not so much. So not all elements should be given the same attention. All depends upon the facts of the hypo.
Absolutely.
Okay, and let's finish up with some of these factors. So another factor is whether the reliance was definite and substantial. To me, what this means is how much. That's the way I view it anyway. How much reliance? How bad was this? You talked about how you felt that the reasonableness of the promisee's reliance gives the court a lot of flexibility to decide whether, I like the phrase, I think you said, whether this merits compensation or merits legal enforceability. Yeah, that's right. And this element too, if you think about it, it does the same thing. This factor. Oh, I said element. Factor. I elevated it. It's just a fact. You're just a factor. Rude.
Very rude.
It is rude. One day I'll be an element. I don't think so. I doubt it. I've seen your work. I really doubt it. Is how much. The way I like to think about it is promissory estoppel is relegated for big deals. I don't mean a deal, it's not a bargain, but big stuff, not little stuff. Not like, yeah, he promised me this and then I like spent $20. Get over it. Next time, get a contract. I tend to think this is like, how much? Wait, I uprooted my whole life. I moved for that promise of employment and I spent all this money, or this promise of the loan. I spent all this money because getting this business ready and then I didn't get the loan. So to me, that second one is also a very important one. And, of course, the kind of thing I like to do is when I write an essay, I like to make facts, not only where you have multiple factors that could be in play with different facts, but the factors themselves could be debatable. So an amount that's kind of in between, like, I don't know, a few $1,000s. I don't know. Is a few $1,000s substantial? Okay, let's make the guy rich. Is it substantial to him? I'm having fun with it. And the point of all this is there's no right answer. And
that's right. And you can have fun with this. Do it, take it and run with it, because this is not a clear standard. This is where it gets fun and you can be creative. And I miss that creativity of very, very wide open doctrines like this. Definite and substantial compared to what? I think there's probably arguments both sides on this, almost by default.
Absolutely. Absolutely. And the last one, the formality with which the promise was made, I think this is an interesting one. This is actually now looking at, I think, maybe the promisor, maybe it's a little bit the promisee and whether the reliance is reasonable, but that's a separate factor. The first two seem to focus on the promisee. This one, it seems to me it's focused on the promisor, the formality which the promise is made. Remember how we talked about formality doesn't make a promise binding. It doesn't in and of itself. But notice what we see here. A factor in whether or not a promise is legally binding under promissory estoppel is the formality with which it is made. So the formality does not make it legally binding, but it is a fact which helps push it in that direction. And that concept is very hard for students sometimes to understand. They think it's either is it or isn't it? Well, it's not a per se, it's not automatic, but it is relevant. And I think the reason we have this factor, which presumably asks things like, did the promisor make it in writing? They don't necessarily have to make it in blood, but did they make it in writing and sign it, for example? Why that seems to potentially push toward enforceability is, I think that this means that the promisor likely gave thought to the promise when they made it. They knew what they were doing. They were thinking about it. It wasn't spur of the moment. And therefore, it is more just to make it legally binding if they went through that formality and thought about it than if it was just something where they kind of blurted out some promise off the cuff without thinking about it.
Yeah, I was just thinking that this is a standard underneath the justice can be avoided only by enforcing the promise. It does seem unfair to not enforce it if it was a formal process or formal environment in which the promise was made. So it's just a fundamental fairness factor, I think.
And there it is. And those are your three elements. And so what you want to do when you are looking at a promissory estoppel essay and you get to element number 5, not only do you want to grab as many facts as you can that would be relevant, you at a minimum, you want to look to see, okay, what arguments can I make about the reasonableness of the reliance? what arguments can I make about whether the reliance was definite and substantial, and what was there formality or not involved in the making of the promise? And you want to probably touch on each of those. Okay, this brings us to our last way to enforce a promise, which is technically not a way to enforce a promise. Really, it's not an actual promise. This is this concept of quasi-contract. And we call it quasi-contract because it's not a real contract. So we're seeing the use of the word contract here really in a way that probably we shouldn't. It might confuse students, because quasi-contract is going to have its own elements, which are entirely distinct from contract and entirely distinct from promissory estoppel. Now, remember how we talked about implied in law promises, promises that the court will infer as a matter of justice. Well, you may have said to yourself, okay, fine. We have an implied in law promise that has been created. What happens to it? Where does it go? What do we do with it? There it is. We talked about one thing that often happens is those implied in law promises go plug holes in contracts, the gaps in contracts. Hey, you go here, and since the parties didn't talk about a time for delivery, you're the time for delivery, and you go and plug that hole. Another thing we talked about was implied in law promise would be designed to avoid unjust enrichment. Well, to avoid unjust enrichment, somebody's got to be ordered to pay. The party who was enriched has to be ordered to pay. Well, this requires not filling a gap in a contract. This requires the creation of a claim, a legal claim in and of itself. And we call this claim quasi-contract. So what happens is, if there has been unjust enrichment, the court can infer as a matter of law a promise to pay compensation, and then use that implied in law promise as the basis for a legal claim to get a recovery from the defendant. And we call that a quasi-contract claim. So a quasi-contract, since it is built upon a fictional promise, an implied in law promise, it is not a true contract. It is just the vehicle in order to get somebody to have to pay when they've been unjustly enriched. Now, I know what you are saying. Unjust is back? Great, another standard. What is unjust? When is it unjust to not pay? Okay, we have some guidance. We could have a lot of factual situations where it may not be so clear, but we do have some guidance. But here are our elements, which are not going to help you. The elements of a claim for quasi-contract are: number one, the defendant has been enriched, so the defendant has received something. Two, they received it from the plaintiff. And three, this is where, this is like element 5, a promissory estoppel. This is where things get tricky. It would be unjust for the defendant to not pay the plaintiff for the benefit received. So the question becomes, when is it unjust? Well, you've given something. We talked about some examples. We talked about that in lesson number 2. We talked about that.
I was just thinking, this is the Best Buy, the TV, the accidental shipping it to somebody who kept the TV. And let me just run this by you, because I don't know if I've got this right. So an implied in law promise forms the basis for a quasi-contract claim. So the claim, the count in the complaint, the alleged cause of action is quasi-contract, but the promise is created by the law, implied in law. Do I have that nomenclature correct?
You do. And we know that some implied in law promises are going to go do something different. They'll fill in gaps in contracts. But those that are being created to avoid unjust enrichment, yes, they're being sent off. I mean, they got to go somewhere. We got to do something with them. Why we're just not going to create them for nothing? They are being sent off and to form the basis of a quasi-contract claim. Now, a quasi-contract claim can go by many different names. A lot of people call it an unjust enrichment claim. We call it a restitution claim. Many courts will use the phrase quantum meruit. That's a very tricky phrase, because quantum meruit can actually, many courts use it not only for a quasi-contract, but also for an actual contract when it is an implied in fact contract. So the phrase, quantum merit is a tricky phrase. It was actually a simplified pleading form, which is getting awfully technical. I think the most important thing for people to recognize is that when you say quantum merit, it means as much as he deserves. Quantum merit can be used both to refer to a quasi-contract or to refer to an implied in law contract. So when people say quantum merit, it doesn't actually answer automatically the question of, well, what is the underlying claim? Which is why the phrase quantum merit can cause people problems, because they may not know. One, you may think you're meaning this and the other party is thinking this, and it creates all sorts of confusion. The court might be confused. So it tends to be a phrase which is probably better avoided, but the reality is a lot of courts use it. So just keep in mind, if you see a quantum merit claim, you want to figure out, okay, is this a quasi-contract or are we talking about an implied in fact contract? But you are correct. The quasi-contract is, the foundation of it is that implied in law promise to avoid unjust enrichment. Now, the good news is we have some guidance on when it would be unjust to not pay for services that have been received. Now, keep in mind here, we're talking about a situation where a contract has not formed. If a contract formed, and has been breached, you would assert a contract claim. You wouldn't assert the quasi-contract claim unless you were doing it in the alternative because you weren't sure if the contract claim would survive. But it is unjust. And remember too, with quasi-contract, since it is built upon an implied in law promise, you don't need interaction between the parties, which is why that name, it's a quasi-contract, not a real contract. So you can have a quasi-contract claim when there's been no interaction between the parties, like you could with your Best Buy hypothetical, well, it's a real case, and with the case I talked about with the steel. So the big question is, when is it unjust to not pay? Well, I should note that it's not unjust to not pay for a gift. You don't have to pay for gifts. I'm not talking about a moral obligation that I should reciprocate at some point and then get you a birthday present. We're talking about a legal obligation. It is not considered under law unjust to not pay for a gift. The whole point of a gift is that no compensation for it is expected. It's a gift. And so there's no requirement to pay for a gift. But it is unjust to not pay for, say, services received when two things are satisfied. Number one, the actions of the person providing the benefit were not officious. Now, people say, what does officious mean? Also, we know what officious means. Officious means basically you're butting in when you don't have to. And, the officious intermeddler is this phrase that's used. Officious means that either you shouldn't have butted in or you could have entered into a contract. There was no reason why you could not have contracted and made an offer with this party. There's some good reason. To be inofficious means there's some good reason why you had to act without contracting. Because again, we want people to contract. If we want to exchange, if I want to provide services, I want to be compensated. We expect me to enter into negotiations, make an offer with you, not just do it and then hold out my hand. So we want to limit quasi-contract claims when it's based upon services provided to situations where the service wasn't provided officiously. There was a reason why. It's understandable that the party would have provided the benefit without contracting. And number two, a reasonable person in the recipient's position would believe that the benefit was provided with an expectation of compensation. Number two is the one which is going to eliminate what a reasonable person would perceive as a gift. So if you think it's reasonable to believe that the person was just giving this to you as a gift and not expecting any sort of compensation, then you can't, it's not unjust to not pay for what a reasonable person would have expected is a gift. So why don't we talk about the two cases? Because we talked about with implied in law promises, two examples, your Best Buy example and my steel example. And then, I'm sorry, actually three. The Best Buy and the steel are kind of in the same place. And then we talked about medical services. And these are going to, let's test these. Let's run these through these elements. These are elements, got to have both of them. Let's run it through and see if the chain holds. And in our hypotheticals, were we right in feeling like those were good quasi-contract claims? So first, was Best Buy acting officiously? Was Best Buy or this butting in where it didn't belong? Now, I guess somebody could kind of say, well, yeah, I mean, they sent it to the wrong guy. That's not where we're going with this. Best Buy wasn't acting officiously. Making a mistake is not acting officiously. It's not butting in where you don't belong. It's a mistake. So that doesn't mean that they are some intermeddler and they're doing something that they shouldn't do and we want to wag their finger. I mean, we don't like mistakes, so we'll wag the finger, don't make a mistake. But that's not kind of the officiousness. That's not what we mean when we say officious. They just screwed up.
Now, you couldn't do this with a TV because you can't send a sample of a TV, but like I'm thinking like a little box of Tide or something. If they're just shipping little boxes of Tide to people, they can't make people pay for that because is that what you mean by officious? They're just like sending you something like to get you to maybe buy a product later.
We are going to talk about that down the road because that's became a problem, because what was happening is companies were doing that. And what they were doing is they were indicating that this was an offer. If you want this, send us the money. And what people were doing is they were using it, not paying it. And we will see a rule down the road that if you receive something, some property that is being offered by a seller, and you, quote, exercise dominion, close quote, over it, you have actually accepted the offer by exercising dominion. So what was happening is people were accepting offers that they didn't intend to accept. And now we can have accidental contracts, so what's the big deal? But the problem is it was creating this incentive for companies to ship all this stuff as offers. And people were forced either to return it or stick it in their closet. They couldn't, throw it out because that's exercising dominion. And the federal government actually got in and passed I'm going to say, I think it's a law, not a regulation, a statute, I think, if I recall correctly, saying that if you received it, you can do anything you want with it with no liability. So the feds, so to speak, got involved in it. I think officious, that's a little different, maybe, in the sense that I'm hoping you'll use it. I think typically when we think of officious, we think of it as I up and provide the benefit to you, and you've got it, and you can't undo that. So I mow your lawn. You're not at home, and I mow your lawn. So you've been enriched, and there's no way for you to undo the enrichment because I've given it to you. So that's sort of.
Yeah, where I think officious, the vision that comes to mind is the windshield washers in the intersections. They just stand there and you're trapped at the red light and they come out and they wash your windshield and you're saying, hey, move along. I don't want my windshield, but they do it. That's officious to me.
It is. And even you might not even be looking, like you're looking down, you look up and it's done. And so they've intermeddled, they've given you some benefit that you're sitting outside or you're on the subway. And they come and they do some dancing or whatever, right? And I guess you could turn away, but you're really getting this benefit. And you have no way, really, realistically, to avoid it. That's officious because we would expect people to, at least in the Tide concept, the argument was, or we're just using that as an example, some sort of generic example of some soap. So a company sends it, and they have an offer in there. So they're trying to offer. So they're not really officious in the sense that they're just providing a benefit without trying to contract and then just get you to have to pay for it. They're at least seeming to try to contract. So we're good with that. But the problem is they are making it difficult for you to reject their offer because you've got the benefit there, it sits. And what am I supposed to, really, I got to return this thing now? I can't even read this. They're almost sort of like trying to trick you, or read the magazine. They're trying to trick you into it. But so we want to make sure it's inefficient. So if somebody gives something by mistake, that's inefficient. We're not mad at those people. We don't feel like they're just trying to get something for free, that they are sort of like, oh, I'll give you this benefit. Now you got to pay for it. And so that holds up in the Best Buy. And we'll stay on element one. In the case dealing with the doctor, if it's an emergency, I remember I was unconscious in the hypo. That's not officious. We assume that if I was conscious, I would gladly accept the help. So they're acting in an emergency, we understand why they wouldn't offer. Can you imagine? I'm unconscious. I have an offer for you. Why aren't you responding? You know, we don't expect them to negotiate a contract because I'm unconscious, or maybe thy house is burning down. I'm not home. We don't expect the person to wait to find out if they can contract. We understand that they need to act now. So those are both the Best Buy and the Steal was a mistake. They weren't acting it's clearly, they're even more so than the Best Buy. They didn't even make a mistake. They sent it to the right place. The other guy just took it. So all those cases, that is inefficient. Officious would be, as I mentioned, I mow your lawn when you're not at home. And then when you come home, I say, I mowed your lawn, give me the money. And I've never met you before. It was not it was not a lawn emergency. And so we're like, give me a break. You're just trying to get something for free. Or not for free.
I'm thinking of an officious doctor who's standing in the supermarket line. The guy in front of him says, oh man, I have a headache. And he immediately begins examining this guy.
Yeah.
like, whoa, get off of me, buddy.
Yeah. Or I would give the hypothetical that, you know, it's a bit creepy, right? But the person, like the dentist, breaks into your house while you're sleeping and removes your tooth. I mean, even if it needed to be extracted, if it wasn't an emergency, which I assume it wouldn't be, we expect the doctor to negotiate, not just to go in there and do it. Number two, the reasonable person in the recipient's position would believe the benefit was provided with an expectation of compensation. So think of the Best Buy case and think of the case with the Steal. The recipient in both those situations, the reasonable person would have understood that Best Buy was expecting compensation for that television set. Best Buy does not just ship television sets to people for free. They may not have been expecting compensation from you because it's wrong TV, but they clearly were expecting payment for the TV. And in the Steal, he obviously understood that they were expecting compensation for the Steal because people just don't give Steal away for free usually. And in
unless they steal it.
Unless they steal it. Exactly right. That joke was a crime. Okay. All right. So the last one with the doctor, the fact that a person providing a service is a professional who gets paid for doing what they are doing, the benefit they're providing, that is almost always going to mean it's reasonable to believe that they are expecting compensation. If they are not in the business of that, then it is reasonable to believe it was a gift. So the doctor who provides aid to the unconscious victim is entitled to a recovery under quasi-contract. And the person who is just a helpful bystander, you know, I stayed at a Holiday Inn Express last night. I'm not a doctor. I don't get compensation. Now you might think that's terribly unfair. The Good Samaritan doesn't get it and the doctor does. But if you think about it, it kind of makes sense. In one respect, it does create the incentive for people who are competent to provide services and people who are not competent to not. And so that's what you're looking for typically with number two. Now, if you had a contract and you had a bargain and it fell through and it wasn't a contract for some reason, you could assert a claim potentially in quasi-contract for any benefit provided, because even though the contract failed, it was part of a bargain. So it was reasonable to believe that the person was expecting compensation. And a couple little wrinkles here is that if you provide if the doctor provides medical care competently to the person and the person still dies, it is still unjust to not pay. It'd be the state, unfortunately, to not pay, because the benefit was the service, not a guaranteed result. And the second wrinkle is that the person, like the doctor, need not be actually thinking about compensation at the time. Let's hope they're not. I mean, that sounds terrible, doesn't it? Like, oh, like the guy at the express lane. I see someone fall unconscious. Perfect. Yeah. Quasi-contract. There's a quasi-contract claim here. So
it's payday in aisle 9.
Yes, this would be terrible. And so even if they weren't thinking about it at the time, the question is really, would it have been reasonable for them to expect compensation had they thought about it at the time. And so those are quasi-contract claims. So the way to think about the difference between these big three are contract are promises that become binding because they're part of a bargain in exchange. Promissory estoppel are promises that become binding because there was detrimental reliance that was caused by the promise. Quasi-contract is not an actual promise at all and is created as a vehicle to allow a recovery when there has been unjust enrichment. And keep in mind, with contract and promissory estoppel, you need interaction between the parties because they're actual promises. Quasi-contract, you don't. And also keep in mind that with promissory estoppel, a promise of a gift can actually be binding. Whereas with a contract, a promise of a gift is not binding because there is no bargain, there is no quid pro quo. A promise of a gift, if you satisfy all those elements of promissory estoppel, could be binding under promissory estoppel.
And when you said all that, in my head, I'm thinking, gosh, this is the issue spotting. This is how I can tell to spot the issue. I'm either facing in the fact pattern, I've got a bargain, a promise with detrimental reliance, or I have an implied in law contract from the fact pattern.
Yep, that would be a very good order and process to take. And obviously you want to spend more time on probably the more viable claim. So if you don't see any unjust enrichment of any kind, then I wouldn't talk about quasi-contract, maybe simply just noting that that claim wouldn't be viable here because there's not. And we can talk about that down the road about, how much time to spend on different topics. But yeah, that is sort of one of the first things that you probably want to do. If the call of the question was very broad, like talk about everything, discuss everything, you probably would want to say, okay, after I talk probably about source of law, now let me see, okay, what are the potential claims here? Probably going to be potential contract claims, a contract class. The real question is going to be, is there also a potential alternative promissory estoppel claim or quasi-contract claim here as well? Okay. And any final thoughts, Steve, or shall we wrap up episode number 3?
I think episode number 3 is in the bag.
Okay. We look forward to seeing you on the next episode. That is all for episode 3.